On Wednesday, the United States Supreme Court agreed to take up a case that, ever since they did so, has sent reverberations all throughout Washington, D.C. and around the country. Now, under normal circumstances, when something like this happens, this doesn't have quite the monumental shock to the system. So, what makes this particular case that four justices agreed to hear so unique? Oh, nothing, except the fact that it involves hundreds of January 6 defendants and one president of the United States who's currently being charged by Special Prosecutor Jack Smith. What does all this mean? Hang on, folks, we're going to get into all this in just 1 second.
My name is Brian Trippett. I am your front porch conservative. Step on up to my electronic front porch and let's talk.
Wednesday morning, a certain level of angst began to creep into the mind of most folks on the political left. That angst, as the day went on, turned into full blown anxiousness, and then by the end of the day, a wailing and gnashing of teeth could be heard all throughout the land from progressives and liberals as they realized the full implications of what could happen depending upon how the Supreme Court rules on a particular case. What is this case, you might ask? Well, let's go to Politico.com and we'll start laying this out for everybody. Headline: Supreme Court will review scope of obstruction law that Trump is charged with breaking. The case calls into question prosecutors' handling of an Enron-era obstruction law to punish those who stormed Congress. Article written by Kyle Cheney and Josh Gerstein. We read the following. The Supreme Court has agreed to take up a case that could derail hundreds of January 6 felony prosecutions and could also deal a blow to special counsel Jack Smith's prosecution of former President Donald Trump. The case, arising from the prosecution of January 6 defendant accused of pushing against police and inflaming a mob attempting to breach the Capitol, calls into question prosecutors' handling of an Enron-era obstruction law to punish those who stormed Congress. The federal charge, obstruction of an official proceeding, carries a maximum 20-year sentence and is one of the four felony counts that Trump is facing in his own Washington, D.C. criminal case. Another count charges him with conspiring to violate the obstruction law. The court's decision to consider the scope of the obstruction law comes as prosecutors in Trump's case are urging the justices to take up a separate appeal over his claims that he is immune from prosecution for his actions related to the 2020 election because he was serving as president at the time. The court's announcement Wednesday that it will hear the obstruction case, which involves January 6 defendant Joseph Fisher, doesn't directly affect any prosecution of Trump by the special counsel Jack Smith, but by throwing one of the charges in Trump's case into limbo, it could bolster Trump's efforts to slow down that case and put off the trial, which is scheduled to open March the 4th. Okay, let's get into this. You read through this article and you start to ask yourself a very important question. What in the world, or how in the world, could a law from back in 2002 that was done related to the cases of Enron and Arthur Anderson, how could that law be possibly used to apply against people who were at the Capitol on January the 6th? And for the record, you're not the only person asking that question. Legal scholars have been asking that one for quite some time now. But what is it about this law that is so useful to people who are wanting to prosecute January 6 defendants? Well, for that answer, we need to go to the law itself and then break down specifically what it says. I take you to a little something that I found vis-a-vis Google. I think you'll find this interesting. 1512 was added to the code as part of the Sarbanes-Oxley Act of 2002. Sarbanes-Oxley was designed to ensure that accountants and investment firms were not destroying documents to impede official proceedings. Now, you ask yourself the question, wait a second. You mean that for all this time, in large part, we've been charging people related to January 6th on a law that has to do with accountants and investment firms whose genesis came out of the Enron scandal? That is correct, ladies and gentlemen. But it's the language of this particular part of Sarbanes-Oxley that is being, in the opinion of many, misapplied. Let's go to the law itself. This is U.S. Code 18-15-12, tampering with a witness, victim, or an informant. Sounds innocuous enough until you get down to the part that is Section C, subsection 2, which reads as follows: whoever corruptly alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both. Okay. You read that and you think about the context in which it was passed, or written, I should say, and you say to yourself, all right, official proceeding, let's say a board meeting, let's say a review of financial documents to make sure that the company is viable, to make sure we don't have any problems. Basically, what they're saying is you can't alter, destroy, or mutilate those records or documents, or you're corruptly trying to influence or impede some kind of official proceeding, a board meeting, a meeting of shareholders, etc. And if you do all that, you get imprisoned for potentially up to 20 years. Now, if that's how you understand that, and I think most people reading the law in light of its context would do so, you again ask yourself the question, how is this possibly being used against people who were at the Capitol on January 6th and subsequently against former President Donald Trump? Aha! That gets to a unique interpretation. For that, we go to Julie Kelly, who is a writer who's been featured in the Wall Street Journal, thehill.com, among other places. She wrote an article back at the beginning of November which explains this very unique legal interpretation and what some would argue is a gross misapplication of the law. In an article called Untested Legal Imaginations, the Mother of Trump and January 6 Prosecutions, we read the following. Donald Trump doesn't know about Thomas Robertson, but the former president's fate appears inextricably tied to that of a former Army Ranger who was convicted last year for his involvement in the January 6th protest at the U.S. Capitol. We go further into this article, and we read the following. One of the key statutes in question is 18 U.S. Code 1512 C2, part of the 2002 Sarbanes-Oxley Act passed by Congress to prevent fraudulent financial reporting by corporations. The statute was meant to close a loophole in other obstruction laws related to the destruction of evidence, but left open to interpretation the terms corruptly and official proceeding in the following passage, to the point where defense lawyers claims it can be used to criminalize political activity. And this is the same passage we just read a moment ago. The DOJ's legal basis rests on the argument that the joint session of Congress held on January 6th to debate and certify the 2020 election was, quote, an official proceeding as opposed to a ceremonial gathering. Those who interrupted Congress, prompting a 6-hour delay or planned to disrupt it, committed that particular obstruction felony, prosecutors contend. Federal prosecutors so far have charged more than 300 January 6 defendants with obstruction under that statute. In August, Smith's office handed down a 45-page indictment against Trump, claiming his attempts to persuade Vice President Mike Pence to reject some electoral college votes, and organize an alternative slate of electors, among other acts, also represented an attempt to obstruct the certification of the 2020 election. Oh, wow. Let's go back up here for a second because I want to read this one paragraph again, and I think when we go through it, you're going to understand why it is lawyers on the political right, among other judicial scholars, have a really serious problem with what is being done against the defendants of January 6th. The DOJ's legal basis rests on the argument that the joint session of Congress held on January 6th to debate and certify the 2020 election was, quote, an official proceeding as opposed to a ceremonial gathering. Those who interrupted Congress, prompted a 6-hour delay, or planned to disrupt it, committed that particular obstruction felony, prosecutors contend. Okay. Words mean things, according to the legendary Rush Limbaugh, and in this case, the words corruptly and obstruction of an official proceeding, those words have meaning, but many would argue their meaning is being stretched way far and wide, so wide and far, in fact, that you could drive the legal equivalent of a Sherman tank through it. Basically, people like Jack Smith and others who are charging January 6 defendants are making the argument that their actions constitute obstruction of an official proceeding because by showing up to protest, and consequently in some cases entering the halls of Congress, delayed the certification of the vote, which was an official proceeding. Keep in mind, however, 1512 of U.S. Code was designed to deal with accountants and investment firms. Basically, that whole argument back then was, look, you can't go around destroying or altering documents on the grounds that you can't have shareholders or board of directors not fully understand the implications of what they're looking at. You do that, you go to jail for 20 years. Oh, but the prosecutors of January 6th got very novel with their interpretation of 1512. They're saying, look, you show up at all and delay Congress in any of its actions, well, that's obstruction of an official proceeding. You have to be jailed for it. And with that interpretation, our friend, Jack Boot Smith, as we lovingly call him here on the front porch, is trying to prosecute Donald Trump. So, how did all this wind up in the hands of the Supreme Court anyway? Well, I'll take you to one more tweet by Julie Kelly. Take a look at this. Hard to overstate the total humiliation of the DOJ and 15 District of Columbia judges who upheld 1512C2. Only one, Judge Carl Nichols, dismissed the count in 3 cases. The beauty here is that DOJ is the one that appealed Nichols. If DOJ would have left it alone, this would not be at SCOTUS right now. Basically, what happened was this. The defendant, Fisher, and 2 other individuals had their case tried in front of a judge, Carl Nichols, who was a Trump appointee. When he got to the question of, hey, is what these guys did, does it constitute obstruction of official proceeding? Judge Nichols basically looked at it and laughed and said, heck no, get this thing out of here. Dismissed all the charges. Well, the Justice Department, not being happy with Judge Nichols, appealed it up to the full D.C. Circuit. And the judges there overruled Nichols and said, absolutely, this is a violation of 1512C2. You can absolutely prosecute him, charge him, and put him in jail. But it was a split decision. Well, that split decision left the door open for Fisher's lawyers and lawyers for the other 2 defendants to appeal it straight to the Supreme Court. And guess what? They took it up. They want to have a hand in deciding whether this law has been over broadly interpreted to do things that it was never intended to. Now, how does all this affect Trump? Well, like I said, 2 of the charges that have been brought against Trump are based on 1512C2, and I'll show you exactly what I mean. This is part of the 45-page document that was handed down in August of 2023. Count 2 is conspiracy to obstruct an official proceeding. Count 3 is obstruction of an attempt to obstruct an official proceeding, and both of them rest on 1512C2. Now you begin to understand why people on the political left in this country are starting to get very nervous. If the Supreme Court decides that 1512C2 has been over broadly interpreted to do things it was never intended to do, not only to defendants of January 6th have charges against them either dropped, reversed, or convictions overturned, potentially, then half of the case against Donald Trump that's been brought by Jack Smith goes right out the window. So this is going to be fun to watch as we go forward, but I thought I'd see what I could do about breaking this down for everybody. Now, this is what I think about it, but tell me what you think. As we start to wrap up this video, please do me some favors. As always, number one, if you're not subscribed to my YouTube and Rumble channels, please do so. Number two, please hit the bell for notifications. I want to make sure you're always aware when new material is coming out. Number three, please leave a comment below. Number four, share the video around. And finally, give me a thumbs up. My name is Brian Trippett. I am your front porch conservative, and I will see you next time.